Welcome to Q&A practice. Let's get started with the plaintiff. Ready? You wanted all the stock. We formed the corporation and we discussed it. The stock was supposed to be issued when the corporation was set up. If I were called to testify, besides objecting on the basis of attorney-client privilege, and to that extent I am not waiving that right, the intention with regard to the children in trust was formed. At the same time, the intention to set up the corporation was formed. There wasn't any latter decision. Let me ask you, Elliot, why was the stock conveyed into the trust? Can you give me an idea for the purpose of establishing the trust? The trust was, as I said it already, you wanted the children to have the stock. The value of the corporation when I set up the two corporations was nil. There was no value. When I discussed it with my attorney, I said, if this is ever worth anything, I want it to belong to my children. If something should happen to me, then it would be conveyed to them. Did I answer the question? You wanted your children to have it, I assume, is the answer. Off the record. Paragraph 1 of the Declaration of the Trust. Do you have a copy of it? I should have copies of everything I provided you. I will read the pertinent part. Roman numeral 1 indicates that the beneficiaries are Jonathan Samuel James and Eric Randall James, that all of the net income will be applied to the trust estate prior to the termination of the trust. It is to be paid in monthly or other convenient installments to the beneficiaries. Have any monies been paid to the beneficiaries? No. Have the corporations had any net income? No. Who would make the resolution as to whether money or other convenient installments would be made? I think the document speaks for itself. Right, that was a nice little warm-up, and now we'll get to our transcript, our other transcript. And we will start with the defense. Ready? And in what way was her language slurred, or did it just not make sense, or what was it that led you to that conclusion that she was confused when you were trying to determine her level of consciousness? She was unable to answer basic questions. Was there anything inconsistent with that state based on your experiences with a pedestrian being struck at approximately 40 miles per hour? Objection, vague and ambiguous. I can rephrase it. Do you understand the question? I don't really know. Did you have an understanding when you first approached Ms. Waters that she had just been the victim of an accident at about 40 miles per hour with an oncoming vehicle? I wasn't told the speed. All I know that the call is an auto versus pedestrian, so I don't know the speed of impact. I didn't know how far the patient was thrown and what actually had occurred. All I knew was auto versus pedestrian. So it was fair to say, when you approached her, you at least knew she was struck by a vehicle, correct? Possibly. And when you initially tried to assess the level of consciousness, determined she was confused, was there anything inconsistent in your mind based on your years of experience in this field with somebody being in a confused state after being struck by a vehicle? I'll object. It's an incomplete hypothetical, vague and ambiguous. It was not normal to me. What was it that was abnormal about that she could not respond to me, and that there was a strong odor of alcohol on her? So, is it fair to say, in your experience treating approximately 10 of these patients per year, approximately, that are involved in pedestrian versus motor vehicle accidents, that you've never experienced a patient that was confused or unable to answer questions because of the mechanism of injury of being struck by a vehicle? I haven't experienced patients that have been in the same state because of being struck by a motor vehicle, meaning a confused state. Yes. Okay, once you went through that series of questions with her, determined that she was unable to answer those basic questions and she was confused, what was the next thing that you recall doing as part of the treatment and care you administered to Ms. Waters? We would have protected the C-spine and got her on a backboard. Did she appear to be in quite a bit of pain and distress at that point when you were doing that? Objection, vague and ambiguous. I don't recall. I don't know. And is it fair to say that the purpose to get her onto a backboard or into a C-spine is to protect in case of spinal cord damage, such as paraplegia, quadriplegia, things of that nature? Yes. And was that a concern that you had as a treating paramedic at the scene, that could be the case based on the mechanism of injury and what you were observing? Yes. And who was it that assisted you in that particular task, if you recall? It would have been myself and the 3 people on the engine company. And while she was being placed on this backboard, is that when you administered these tests and went through a number of the things that are identified here on this pre-hospital care report? I can't tell you exactly when all of them were done. It was either on scene or en route. This type of situation is a load and go type situation. It's a neurotrauma, and it's important to get them off scene as quickly as possible. So we do what's necessary on scene and what we have time for, and once the ambulance gets there, we load them in and continue all the treatment en route to the hospital. So I'm not sure what was done actually on scene unless it was documented with time. And were you one of the treating paramedics at the scene that made the independent decision that this was going to be treated as a head trauma case? Objection, misstates his testimony. Do you understand? It's not an independent decision, but yes, I did make the decision. collectively with the other treating paramedics? Yes. That will conclude our Q&A practice.